Colleagues,
Yes, I'm ready. Can I start, Rutsani?
we are live.
Good morning. Welcome to CIPC's live broadcast. Today, our topics will be Companies Amendment Bill. The webinar will be on the Companies Amendment Bill. Now, a brief introduction on our webinar will be that the Parliament released the Companies Amendment Bill for public comment on August the 28th, 2023. The objectives of the commissions include the promotion of education awareness of company and intellectual property laws and related matters, Section 186, subsection C of the Companies Act 71 of 2008. Through the implementation of education and information awareness sessions to ensure that the public is well informed about what they can anticipate regarding these bills. The bills are the company's amendment bill, the company's second amendment bill. So today's webinar, we will be providing information on the company's amendment bills itself and offer guidance on legislative requirements. Our presenter today will be Lucinda Stienka. She's a senior legal advisor at CIPC in the corporate legal division. Ms. Stienka, please welcome. You can introduce yourself.
Thank you, Shani. Good morning, everybody. I hope I'm audible.
Yes, you are.
Yeah.
Okay, perfect. Thank you again for this opportunity. So what I'm going to do today is just take everyone through the company's amendment bills. There are two of them, and their key amendments in relation to those bills. It has been presented to the portfolio committee from Parliament for approval and published for public comment. So what we are going to do today is just look at a few key amendments to these bills. I am not going through every single amendment, but just highlight the ones that we felt were key. So without any further ado, okay. So just a bit of background. The Department of Trade, Industry and Competition is responsible for and the custodian of various pieces of legislation, which includes the Companies Act. And the CIPC is tasked with enforcing this act in line with the functions and objectives as set out in sections 186 and 187 of the Companies Act. Section 188 of this Act provides further for the Commission to advise the Minister of the DTIC on matters relating to company and intellectual property law, and importantly, recommend changes to bring the law and the administration of the Act in line with international best practices. We have seen many changes to the Companies Act in recent times, most noticeable the introduction of the beneficial ownership concept through the promulgation of the General Laws Amendment Act, which was promulgated in December of last year. In 2018, the Companies Act was reviewed by the DTIC to identify certain deficiencies and anomalies within the Act as discovered through implementation. The Companies Amendment Draft Bill was published in the Government Gazette for public comment in September of 2018, followed by extensive public engagements. However, the process of review was interrupted by COVID-19. Following the conclusion of the engagements, the Companies Amendment Bill was published for a second time in October of 2021. After careful consideration of the submissions and comments on the draft bill, certain amendments were done, resulting in the current Companies Amendment Bill of 2023. The findings of the Judicial Commission on State Capture, the Zondo Commission, resulted in the development of a further bill, the Companies Second Amendment Bill of 2023. Both these amendment bills are aimed at correcting deficiencies within the current Companies Act, simplifying certain complex issues, and rectifying anomalies as far as possible. Okay, so some of these key amendments. Section 16 of the Act relates to the amendment of a company's MOI with uncertainty relating to the effective date of such an amendment. We've seen a lot of that coming through from the queries on the MOIs. When is it effective? Effective date from the date of the resolution, which no longer lapses in terms of the Act, or is it only effective once it has been filed and accepted by the CIPC? So the proposed amendment is that the notice of amendment will take effect 10 business days after filing that amendment with the CIPC, provided that the CIPC has not rejected the amendment application. If it is accepted by the CIPC, before the effective date will be the date of registration. So what happens is that if a MOI amendment is filed with the CIPC and within 10 business days from the date of filing, it has not been endorsed or rejected by the CIPC, then that is the effective date of that MOI. However, if it is registered before the 10 days has passed, then the registration date is the effective date of the amendment. Section 25(2) provides for the location of company records to be filed with the CIPC. We all know this. If changes or if it is not the same as the registered address of the company in the form of a COR 22, the proposed amendment to the company's amendment bill is that the Commission is to publish a list of the location of company records of these companies. So a list of COR 22's applications that were filed and accepted by the CIPC will then be published for transparency reasons so that the public is aware of where individual companies' records are located in order to request access. Section 26, the list of documents to which access must be given does not include the beneficial interest register. We are all very well aware of the beneficial ownership concept that was introduced late last year and early of this year. And the beneficial interest register does not form part of the documents that must be disclosed in terms of Section 26. The proposed amendment is for the beneficial interest register to be included in this list, to which there is a right of access in terms of Section 26(1). However, the right of inspection of documents will not apply to private, personal liability, or non-profit companies with a public interest score below the prescribed threshold. Section 34, there is no obligation to name the directors and prescribed officers that receive remuneration or benefits from a company, only the particulars of the remuneration or the benefit. The public interest score applies and only applicable to companies required to have audited financial statements. This proposed amendment is for the disclosure of the remuneration or benefits in the financial statements of a company to include the name of the relevant director or prescribed officer receiving the remuneration or the benefit in line with the public interest score as mentioned above. Section 30A is an inclusion in the Act, a new section to address the deficiencies relating to equity between directors and senior managers on the one hand, and shareholders and company employees on the other. The proposal is for the new section. It will place a statutory requirement on public and state-owned companies specifically to provide for a remuneration policy for their directors and prescribed officers, and this policy will be subject to approval by ordinary resolution at the AGM of a company. The consequences for failure to obtain the necessary approvals is also highlighted in this section. Section 33, all companies are required to file an annual return, including a copy of its annual financial statements. This is very burdensome for small companies. The proposed amendment will see to the filing of annual financial statements that will only apply to public and state-owned companies or any other profit or non-profit company with a public interest score higher than the threshold, as set out in Section 30, subsection 2, or Regulation 30, subsection 7. Section 38A there's no remedy in terms of Section 38, in terms of the issue of shares, for a court to validate the creation or the allotment or the issue of shares. An example is where shares have been issued more than that which is authorized, which results in all the money received for those shares to be paid back to the shareholders that paid for them, etc. The proposal is for the empowerment of the court to validate otherwise invalid creations, allotment, or the issue of shares if good reasons exist for that. So the courts are to be empowered to validate such invalid issue of shares, and that will make the process much easier. Section 118. The Takeover Regulation Panel has jurisdiction over public companies, state-owned companies, and certain categories of private companies. Limitations imposed on certain categories of private companies proved to be unnecessarily burdensome as well. In an attempt to ease the ease of doing business, the proposed amendment is for the Takeover Regulation Panel to have jurisdiction over public companies, state-owned companies, that remains, and private companies only in the following circumstances: where a private company has 10 or more shareholders, or where a private company exceeding the threshold of annual turnover or asset value, which is still to be determined by the minister in consultation with the Takeover Regulation Panel. That is where the TRP will also be have jurisdiction over private companies only if those two requirements are in place. Section 135. During business rescue proceedings, there's a moratorium on legal proceedings against the company in business rescue. Furthermore, a landlord renting to a company in business rescue remains responsible for municipal services, which cannot be recovered from the company. If it's not paid by a landlord, this could result in termination of basic services such as water and electricity. The proposed amendment is for landlords of a company as a tenant that continue to pay for municipal services will have a preference claim as the provider of post-commencement finance. The payment of such utilities should then be regarded as providing post-commencement finance, and these landlords will have a preferential claim against in terms of the business rescue plan once that is published and accepted. Section 160. Name objections may be directed to the company's tribunal for adjudication, which in some cases results in an order for the respondent company to change its name. However, the Act does not provide for a specific time period within which such changes must be effected, and often results in the applicant having to return to the company's tribunal to enforce the order that was issued in the first place. The proposed amendment is for the company's tribunal to indicate the date. It can be 60 days, 90 days, it's not specified, in terms of which the order must be effected. After such time has lapsed, the applicant does not need to approach the company's tribunal again for enforcement of that order, but may approach the Commission directly to change the respondent company name to its registration number to give effect to the order. The key amendments in terms of the Second Amendment Bill, as I mentioned earlier, the Second Amendment Bill was as a result of the Zondo Commission or the State Capture Report. In terms of Section 162, applications to declare directors delinquent or under probation. That's what that section provides for. An application for delinquency may be brought before a court if the person concerned is a current director of that company or within 24 months immediately before the application for delinquency was a director of that company. The Zondo Commission findings included recommendations concerning 2 specific companies and applications for delinquency related to persons involved with those companies as directors or prescribed officers. Unfortunately, due to the extensive time taken for the State Capture Report to be released, the time bar of 24 months was already applicable. The proposed amendment thus was for, although the recommendation by the Zondo Commission was limited to specific companies, it is considered in general public interest to extend the time bar from 24 months to 60 months. The time bar in terms of applications for delinquency declarations must be fair to both the applicant and the respondent, and thus cannot be allowed to be open-ended or indefinite, and there must be a specific time bar in place. In certain circumstances, the courts may be empowered to extend the period of 5 years even further on good cause shown. Most importantly, the extension of the 60-month period on good cause shown will have retrospective effect. Section 77 is in line with that in terms of Section 162. In terms of the liability of directors, a further time bar of 3 years exists within which a claim for damages or loss against the director may be brought. The proposed amendment to this section is empowering the court to extend the period of 3 years on good cause shown, including having retrospective effect, to submit a claim for damages or loss against a director. In a nutshell, that is just the key amendments in terms of these two bills. There are certain sections that was not highlighted in this presentation. You are all urged to have a look at the two different amendment bills that were published for public comment early September. It's also available on the DTIC website for you to view. And there will be extensive public engagements on these two proposed bills that we've been waiting for close to 4 years now. And your comments will be absolutely valued in this to get these two bills promulgated and approved. Thank you very much.
Thank you so much, Lucinda. We may start asking questions. Is there any questions that is put in our comment section? Will the beneficial ownership deadline be extended? Okay, I don't see how that's related to company amendment bills, but Lucinda, would you like to answer that question?
Sure. This webinar is specifically for the amendment bills that I've discussed just now. It's not for beneficial ownership, but there is no deadline in terms or a timeline in terms of beneficial ownership. Have a read of the notice 53 of 2023 that was published that specifically relates to companies need to comply with the legislative requirements, and enforcement procedures in terms of that will be followed by the CIPC. There's no extension. Thank you.
Thank you so much for answering that question for us. Is there any question relating to companies' amendment bills? Okay, I see there's no question relating. Well done, Lucinda. This is amazing. Your presentation was so informative. We don't have any questions. That's really, really good. Okay, we will give 5 more minutes for any questions to come through. Is there any other part of company amendment bills that you would like to expand on, Lucinda, to just clarify anything relating to the company amendment bills so that we can at least give our audience a few minutes to ask some questions?
Probably on our side, Shani, just to confirm that everybody to which the bills apply need to go and have a look at the content of the company's amendment bills, both of them. As I said, I did not highlight every single amendment, so only key amendments in relation to the CIPC as well. So it is very important to have a look at those amendments and to have your say as a member of the public on the application of these bills, as well as during the public engagements to dates of which, etc., is all published on the DTIC website. So please go and have a look there.
Okay, this is a question. Technically, Kali's question is, please provide more of an explanation to the Section 45 amendments. Do directors need to sign off the resolution if it is an interrelated loan?
Okay, so Section 45 is one of the sections in terms of the amendment bill that I did not highlight in the presentation. So providing a loan needs to be signed off, but I think I cannot recall now. Please go and have a look at the legislation itself, but if I'm not mistaken, it needs to be approved by the company itself, by the shareholders.
Okay. The next question that we have, what are the PI scores threshold?
So the PI score, public interest score, is explained in the current Companies Act and the regulations. It is a calculation that is made based on the workforce of the company. If there is the size of if there's any contractual obligations in terms of that company, is a calculation. And that our calculation is applied when doing the public interest score. So for each company, they will go and have to have a look to the calculation itself to see whether they will fall into the requirements as provided for, like the takeover regulation panel application, like the requirement to file audited financial statements. All of that is related to the public interest score, which it is related now as well. And the Minister of the DTIC will also, together with the takeover regulation panel, still work on the specific conditions in terms of these private company applicability to the takeover regulation panel.
Okay, thank you for that. Next question from Ashley. Is there anything specific that will need to be filed with CIPC relating to these amendments?
No, the amendments does not provide for any additional filing with the CIPC of anything new, except for the beneficial ownership requirements. These amendments just give clarity on certain aspects, like the MOI amendment effective date, that it's normal filing, business as usual, if there's a name change, if there's a type change, whatever the case may be for an MOI, but that certainty is placed in terms of this bill for the 10 business days for the CIPC to either endorse or reject that filing. If it does not happen within those 10 business days from date of filing, then it is accepted that the effective date of that MOI amendment and the resolution passed is then 10 business days.
Okay. Our next question is, when is the expected date these bills will be approved?
We have, as I mentioned in the presentation, these amendments have been coming since 2018 already. So the minister is very eager to get these amendment bills through as soon as possible, but we have to follow the legislative process, which includes publication for 30 days in the Government Gazette for public comment, which is followed by public engagements, where there's specific debates and inputs and submissions on these bills by the members of the public and other stakeholders, including the CIPC, after which all those submissions will be taken into account and considered. If there's vital amendments that still need to be made to the bill, then it goes through a further process of publication. But we are looking, hopefully, by early next year, March, April. You cannot hold me to that. It depends on the process, but the minister is quite keen for these bills to go through as soon as possible.
Okay, thank you for that. Technically, can a company use the auditors/accountants address for Section 25, subsection 2?
So this relates to the location of company records. If your company records are located at the auditor's or accountant's office, then that is the address that will be provided. It's very specific. where your company, where your financial statements are, where the resolutions of the company that were passed are, etc. All of that information, if that is kept with the auditor or the accountant of a company, then that is the location of company records, and that address can be used.
Okay. So what is meant by higher than the threshold in terms of the ARs? Will this be higher than 350 or 500? Or is this specified in the law somewhere?
Yes, so the threshold is of the public interest score is not the annual returns threshold. So the public interest score threshold that is mentioned in the legislation needs to be looked at.
Okay. Is there another question that we have? Okay, I see the other question that we have is, will the published list of the location of company records be public?
Yes, the requirement for this list is for transparency purposes. So the same way that the CIPC publishes the list of businesses in business rescue, the same way that the CIPC publishes the liquidation list, companies that are in liquidation, all of those lists, this will be added to that, a publication of the lists of companies where their records are located in order for members of the public to apply to the company to have access to those records.
Thank you very much. Is there any other questions? I do not see any more questions that we have. Lucinda, would you like to round up the session? I know it's a bit early, but as we do not have any other questions, and we got very positive comments on our comment list on Facebook, please can you do a closing for us?
Thanks very much, Shani. Yes, my colleague, Mr. Monyela, is part of this streaming today, and I'm informed that most of the questions have already been answered in the chat, so that's wonderful. Just from my side, everybody, the amendment bills, as I said, there's key requirements in terms of these amendments. The purpose is to correct any deficiencies, any uncertainties, any anomalies that were found in the bill as far as possible through implementation that we've done now for the better part of 10 years and more. And I think that most of these amendments will make the process of corporate governance less cumbersome, especially for our smaller entities. So I think it is a very good thing of these amendments coming through, and I think it will have a positive impact on the ease of doing business. So thank you for your time and thank you for listening. If there are obviously, as usual, any other queries in terms of the amendment bills themselves, these should be directed to the DTIC, specifically comments. Once they are incorporated, then the CIPC will, of course, explain in further detail how that impacts in terms of the regulatory process from our side. Thank you very much.
Okay, listener. Thank you very much for this presentation. Please, any other questions that's not related to the company amendments bill? I see on our site we have a few questions that's not related to the bill. Please, can you direct them to the CIPC query resolution section? Thank you very much. Thank you, guys. We really appreciate this very informative presentation. Remember, the presentation is on the CIPC website. You can view it and download it from our website. Thank you. Goodbye.